On Spectrum tonight, what is the position of the Uganda Law Society on some key emerging issues in the justice, law and order sector? A number of legal issues that touch on the core of human rights, justice, law and order have recently emerged in the country, calling for guidance from those who have competence on such issues. These issues include the right to bail, sparked off by a proposal by President Museveni to have the constitution amended to tighten conditions for bail for a certain category of suspects. This proposal has divided the country, and it is currently being viewed as purely political and not demand-driven as presumed by the Constitution. Another issue that has emerged in the past but keeps emerging again is the argument about the rule of law and what it contains. This has largely been sparked off by the prosecution of FDC President Dr. Kizza, who keeps on stressing that the Ugandan government is using legal gymnastics to curtail his own rights and freedoms. The independence of the judiciary has once again emerged tested following reports that President Yoweri Museveni has pronounced himself about the ongoing prosecution of former VP Gilbert Bukenya, even though many in the judiciary and the political domain have said this is likely to influence the outcome of this particular case. Lastly, but not the least, is the growing demand to have the death penalty abolished in Uganda, with many people saying it contradicts modern principles of rehabilitating criminals. The Uganda Law Society is one of the statutory bodies that is mandated under the Ugandan law to protect and assist the public on matters touching on laws. So tonight, we will tap into the knowledge of the Law Society to see how they perceive these issues, which are driving debate within the political and legal domains. Our guests tonight, Mr. Oscar Kihika, Senior Advocate and former President of the Uganda Law Society. You're most welcome, Mr. Kihika.
Thank you very much, and good evening, listeners.
We also expect to be joined by Ms. Grace Babihuga, an advocate as well, and Executive Director of the Uganda Law Society. We believe she's on her way to this place. Right now online we have Mr. Arias Chisauzi as well, the spokesman for the judiciary. You're most welcome, Mr. Chisauzi. He's with us on the line. You're welcome, Mr. Chisauzi.
Thank you. Good evening.
All right, Mr. Chair, let's start with you. The right to bail. Under the Ugandan Constitution, bail is an entrenched matter, even though discretion is exercised by court, which may tag conditions on bail. Why would the president say, people suspected of murder, economics, what he calls economic sabotage, rioting, defilement, and rape, should go to jail for 6 months before they are actually given bail?
Yeah, you're quite right when you state that bail is the right
Hello?
to bail.
Yes, Mr. Chisauzi, we're still with you.
I'm not hearing well. I think the voice somehow is...
Okay, it's going to be work. Somebody's going to work on it right now.
the line is not very clear. It's not...
Go on.
Yeah, you're quite right. Bail is enshrined as one of the rights in the Constitution, particularly I think Chapter 4 of the Constitution, which spells out the fundamental rights afforded to the citizens of this country. And particularly, from my recollection, it's actually Article 26, which basically spells out the right to one's freedom, or if you can call it the right to be prevention from illegal incarceration of somebody, the freedom to move freely. Now, of course, that becomes rather qualified if that person is subject to court proceedings, and particularly criminal proceedings. But again, it has to be remembered that even when one is subject to criminal proceedings, he is presumed innocent until otherwise pronounced by the court. And to that extent, he or she still enjoys the right to freedom of movement, and he shouldn't be incarcerated unduly. Therefore, the Constitution then gives that person the right to apply for bail. And because that right is enshrined in the Constitution, that right is inalienable. Okay, so if, say, for example, you're accused of any offense, the Constitution states that Article 26, I think, sub-Article 6, provides that if the offense is triable by the High Court and the magistrates, concurrently, the person who is so charged, I think, is entitled, he would only be incarcerated for 120 days, and then thereafter both courts would be would have to release him on terms and conditions that they would feel fit, the courts that is. Now, if it is a serious offense, more serious offense, and one that is triable by the High Court only, then that person is in the Constitution provides that person can be incarcerated for only up to 360 days, and then thereafter the court would be obliged to release him or her on bail on terms and conditions. Now, you see, the disquiet that is coming from, that has been expressed by the Law Society, and here I have to state that I'm representing my president, James Sebugeny, who's not been able to come here, but has delegated me to come and talk on behalf of him and the society indeed, is that, you see, the president's recent pronouncements regarding toughening of these bail conditions infringes on these particular principles that I've actually outlined. The fact that if somebody, for argument's sake, I think he's proposed that people who demonstrate, right, illegally,
yes,
economic saboteurs, I think that is a matter.
It's a very broad one.
Very broad one. I don't know whether I stand to be reminded. I don't know whether the other categories. When he states that
murder, economic sabotage, rioting,
exactly,
demonstrating, walk to work.
Yeah. Okay. Now he states that those people must first be incarcerated for 6 months. Now that in our view goes contrary to the principle that one is innocent until proven guilty, because you're already imposing in the first place a 6-month jail sentence.
So that's the term on its own.
Yes, that's yes, it's a sentence. Literally, practically speaking, all right, and it goes against the spirit of the Constitution, that you are entitled to your freedom of movement, freedom from unlawful, incarceration. So what he's suggesting and is that it goes against the tenets of the rule of law that have developed over a period of time, right? The civil liberties of the citizens, and that is broadly speaking. Okay, that's where the concerns of the Law Society come in. But perhaps if I'm allowed to go even one step further, the disquiet we feel we have as the Law Society is that it appears we may be wrong, but the perception here is that you're targeting people that probably do not agree with your views in government. And I think the president or the executive need to understand that every citizen is entitled to an opinion on the way they are being governed. And they have got to remember that when we go to the ballot box and elect them, or when I go to the ballot box and express my opinion, my view and my wish, I am entering into a contract with you, in the sense that I am agreeing to be governed, all right, in accordance with the Constitution, and that my rights are not going to be trampled upon by you, because I'm delegating to you this extreme power, all right. But this power must be exercised, if I might use the word, or look for a better word, judiciously and fairly, so that my rights are not trampled upon.
Right.
Okay. Whether or not I agree with you, whether or not I voted you in,
right.
But yes, the fact that I participated in the electoral process doesn't take away the fact, even if I did not vote for you, all right, but I accepted the result that you are my president, right? You nonetheless have you're bound to me, contractually speaking, if I will, all right, to serve me as well, and therefore not to trample on my rights. Now, the executive must understand, and the president, I think, must understand, and I say this with all due respect to him and the office that he holds, that if I express a different opinion by way of going on the streets, all right, to express that opinion, it's my right, right? And it's my right to do so in the first place. Secondly, if you disagree with me, you cannot punish me by
locking you, keeping you out of circulation.
Okay? Because then that breeds, I think, in my view, I'm not a politician, but as a political observer, I think what you're actually doing is you're, in the long run, exacerbating the whole problem.
It's kind of detention without trial.
Yes, exactly. It's a clever way of introducing that act, which was one of the first acts that President Museveni repealed in 1986. You know, the Detention Without Trial Act. That's the most infamous one.
Right.
Okay. So, and that's the basis upon which the Law Society feels rather uncomfortable.
Right.
As I conclude in these opening remarks on this particular point, I think, and perhaps we'll touch it. You must allow the institutions that are charged with the responsibility of determining whether or not to grant bail to operate, and that institution is none other than the courts. And that's why they're there in place. That they allow them to exercise their discretion. And besides, you see, that discretion has also got to be determined judiciously. And I think the courts are there to act in the interests of the public. But so by making such pronouncements, you're saying that you have no confidence in the judiciary as an institution,
right? And
therefore you take away the power to exercise that discretion for a certain period of time. So we feel basically uncomfortable, and I'm urging the parliamentarians, if that proposal is ever tabled before them, to
throw it out,
to seriously consider the ramifications of such.
Maybe they should just throw it out. You say it is detention without trial. You don't want detention without trial coming back.
No, we don't.
It might even be amended to say 6 months or longer than 6 months.
It might even be
1 year.
Yes, and that's the thing. And what the parliamentarians must learn. But let's go back into history. The very people that used to rely on that act,
the detention without trial,
yes,
introduced by Milton Obote in 1966,
exactly, became the victims.
Matthias Ngobi and somebody else.
Absolutely, there were others. Those were the more prominent ones. But there were other citizens of this country who suffered. But this is something that we must go back into history. And this history is not very far back. Okay, and it's I might remind the executive that that was one of the reasons why there was a lot of disquiet, particularly even during the Obote 2 days. And that's where sometimes I want to believe that their struggle was, in quote unquote, supported and to a limited extent legitimatized because of these very, very concerns. When you shut up opinion, whether you like it or not, what you're basically doing is you're bottling it, right? But you're not going to explode. It's from another place. At some point in time, it's going to explode. So what we'd rather do is encourage open dialogue. And that's what happens in a true democratic society.
Let's get this. When you said inalienable right, let's get it clear. It means a right that cannot be taken away.
It should not be taken away.
It might not be a very common term.
It may not be a very
inalienable means something that cannot be taken away.
Exactly.
You've also said that basically what President Museveni is trying to bring out is a resurrection of the detention without trial, basically.
In a roundabout manner.
In a roundabout manner. Except
that for those who probably don't know what this act said, that at that time the Minister of Internal Affairs could, by order, actually detain a person without trial for open.
Right.
Now this one here is restricted.
Here is saying it's more civilized.
It's restricted for 6 months. But you see, if I am at the end of the day, if I am being incarcerated for expressing my opinion, right?
Yes. Or
expressing my right, right? By way of demonstrating, which right is enshrined in the Constitution.
Yes.
Okay. Then you start getting into very murky waters of creating what you call political martyrs and prisoners. So I'm here to talk about the law, but you can't talk about the law without the underlying context of it. And I would implore the executive to really re-examine this provision or this amendment, because I think it's going to have quite a bit of ramifications in future.
Listeners, this is Spectrum on Radio 1. Tonight, what is the position of the Uganda Law Society on some key emerging issues in the justice, law and order sector? We cannot be joined by Mr. Elias Chisauzi. There's a problem with our line. He's a spokesman for the judiciary. But in the studio with me right now, I have Mr. Oscar Kihika. He's a senior advocate and the former president of the Uganda Law Society, representing the substantive Law Society president who could not come. You'll be able to call in later. For now, Mr. Kihika, you're saying what the president is trying to do is to really clamp down on open dialogue.
That's the perception. That's the perception we have. I mean, you see, look, we do not expect the executive to be happy. They are human. Any person is human if you're being criticized, right? But again, I should state this: the executive should always remember that they are there because they have entered into a contract with the population of Uganda to uphold the constitution. That's what they swear to do, okay? To protect and preserve it. And in that constitution, it enumerates a number of rights that we, the citizens, are entitled